Welcome everyone to our last panel of the day, SEC Practice, Best Practices in Testimony, Wells Process, Parallel Criminal Proceedings, and Settlement Negotiations. Our moderator for the last panel is Michael Birnbaum, who is a partner at Morrison and Foerster in New York. He is the co-head of the firm's New York litigation department and a partner in the securities litigation, securities enforcement, and white-collar defense group. Before joining Morrison and Foerster, Michael served in the SEC for 11 years, most recently as senior trial counsel. Throughout his tenure at the SEC, Michael worked closely with SEC investigative units, including the AMU, the Market Abuse Unit, and the Complex Financial Instruments Unit. Next to Michael is Greg Bruch, who is a founding partner of Bruch Law Group, a boutique law firm in Washington, D.C., specializing in government investigations before the SEC, DOJ, and other financial industry and banking regulators. Greg also worked in the SEC's Division of Enforcement for 12 years, the last 5 of which he was an assistant director, where he was responsible for many of the agency's significant enforcement actions. Next to Greg is Sandra Hanna, who is a partner at Steptoe, where she leads the firm's SEC enforcement practice based here in Washington, D.C., as well as in New York. Sandra is continually recognized as a nationwide leader in securities enforcement matters. She represents public companies, regulated entities, audit firms, and senior executives in regulatory enforcement matters. Next to Sandra is George Kostolampros, who is a partner at Venable here in D.C. George advises and represents clients in investigations and litigation brought by the SEC, CFTC, DOJ, FINRA, and other government agencies and SROs. Prior to joining Venable, George was a senior counsel in the SEC's Enforcement Division in New York and Washington, D.C., where he investigated federal securities law violations, including accounting fraud, improper mutual fund trading, market manipulation, and FCPA violations. Moving down the row, we'll find Michael Maloney, who is Senior Managing Director at FTI, also in D.C. Michael is a leading expert in forensic accounting investigations, white-collar criminal and civil defense, and matters involving complex accounting, auditing, financial reporting, and fraud issues. Previously, Michael served as Chief Accountant of the SEC's Division of Enforcement. And at the end of our panel here, we have Sam Waldon. Sam is the Chief Counsel for the SEC's Division of Enforcement. He joined the SEC in that role in March 2022. Prior to joining the SEC, he was a partner at the law firm Proskauer Rose. He was also previously Assistant Chief Counsel for the SEC's Division of Enforcement, and earlier in his career, he was a senior counsel in the division. And with that, Michael, I'll hand it to you.
Thank you. And as you mentioned, I know we're the last people keeping you from happy hour on a day that some have said calls for a drink, so we will land the plane on time, I promise. I thought I'd start by asking some questions about testimony and kind of from a perspective of every first-year associate, which is what's the difference between testimony and a deposition, and how do we prepare people when they walk in? So Sandra, is there a difference, and is there a difference in how you think of walking people into a room for SEC's testimony?
For sure. First, thank you to the diehards that are still here at 5:18, the day after the election. We're happy to bring you the Bruch Hanna Comedy Hour to get you through to cocktails. Yes, there is a deposition, and there are some junior associates, a difference between deposition and testimony. I'm not going to spend a lot of time talking on it. About depositions today, but testimony, for those who are new to it and those who need a reminder, is where we earn our money, in my view. I think it is, and I know many of you in the room agree, this is the single most important thing that we often do as defense counsel, because testimony is not just your time in the room, it's the hours and days you spend before you meet with your client for several days in the room. It's the many days in the room. And the goal, in my view, is a return to first principles. The only thing I want from clients in testimony is accurate and truthful. That's it. in my view, there's no themes, there's none of that. Let's just go for accurate and truthful. And everything else that we do for all of the days and all of before testimony and the many days sometimes in testimony is in furtherance of that goal. And if we don't get that right, all the other things that we're going to talk about today go wrong. So it really is the most important thing that we do. And we have to spend the time and spend the hours. They have to make the time. I have to make the time. You have to make the time. The associates have to make the time. I don't know what the right ratio is. Some people say for every hour of prep with the client, there's 10 hours of prep without the client. Right? And then maybe the ratio then is like of prep time to testimony is 3-to-1, 3 days of prep for 1 day of testimony. I don't know what the numbers is, but it's in that range, right? If we do it right, because we have to keep pulling the threads so that the client can return to first principles in testimony, which is accurate and truthful.
So how do you answer when a client says to you, "What am I supposed to say here?"
Well, what do you remember? Let's start. Right. What do you actually know? Let's start there. What do you actually know? Not what you think you know, not what you think they want to hear, but what do you actually know? And it breaks my heart a little bit when Sanjay earlier today and others have said it, when the client goes in or the government's view of your client is like, all they say is, I don't remember. That's typically not true with our clients unless it's actually accurate and truthful, right? Like that. So I don't know what you're supposed to say. Let's spend 8 hours figuring it out. Like, what do you actually know?
I think, well, the way Michael phrased the question earlier, like difference between civil deposition and SEC testimony is really important because in a civil deposition, for any of you who have experience in commercial litigation, you'll frequently have witnesses that you spend very little time with. And you'll say, well, these are the themes. These are the themes. This is what the company is. It's important to the company. And I'm not completely comfortable with that, but that's how it's done. And it's an absolute disaster if you do that with a client for SEC testimony. When a client says to me, what should I say? I say, I'm not going to tell you because if I give you lines to say, you're going to flub them. Right? You're not going to be believable. They're going to eat you up. So your response was better and more respectful, which is, let's go back to what you really know. What do you remember? Let's start from there.
Yeah.
So what about for more technical witnesses? Have you used consultants? And Michael, I know you sometimes have helped prepare people. What do you find could be a useful role for the non-lawyer to help prepare?
Sure. I think for technically oriented witnesses, particularly for SEC testimony, and folks like us spend a lot of time working with counsel to help prep those witnesses. Just a couple examples that I think to keep in mind that can turn out to be really troubling and really haunt the witness is when you have a highly technical, whether it's an audit partner or a senior accountant at a company. They know a lot about their area, and typically these are people who don't testify for a living and don't come in, but they want to tell their story, particularly if they are a respondent of interest. I've had one situation recently where, despite the prep, the witness went in and was giving answers that were 2 and 3 pages long. And counsel, and I know that's for all the lawyers in the room, you don't want your client doing that. There's a balance there. And despite, good facts coming out through the course of the investigation, the staff continues to come back to say, yes, but the testimony was so all over the place that we're really bothered by that person. Another is when you have a highly technical witness who has a certain view about, let's say, an accounting standard. I had this example recently. And in prep wasn't really explaining it in a way that you could tell was going to be convincing to the staff, had a certain view about how a certain part of GAAP was applied. And it's really important to try to coach them to answer it in a way that is accurate and truthful, but is also going to be something that the staff will hear in a way that is positive. And in that situation, again, despite all that prep, the person went back to their kind of usual way of thinking about that issue and, scrambling at the brakes to try to get them to correct it. And so again, became, as the investigation played out, something the staff continued to point back to and say this testimony was really a problem for us. So those are just a couple of pointers where it can be helpful to really.
How much time did you spend in prep for that? Was it, it wasn't enough, right?
It wasn't enough. Yeah, it's typically a day or two, and every situation's different. But it can be really helpful to spend that time.
I would add to that, and I look through this room and I see a number of forensic and accounting experts here who have played an invaluable role in educating me as counsel. Right, so it's one thing to help prepare the witness. It can be very valuable, but as a lawyer, we encounter all the time people in specialized areas where we just don't know. We're not experts, we're not accountants, we're not geologists. To have somebody like Michael or Susan or any of the others who are in this room who can say, well, let's schedule a time where you can have a tutorial. I'll answer all your questions, I won't make you feel stupid, is just incredibly valuable when you get in there.
So I have a question for Sam, and I know you're too modest to mention it, but I think your bio may have even gotten more impressive since we first submitted that. But we heard this morning from Sanjay, to paraphrase him, that even if you don't get as many meetings as you might want with the front office, don't worry, the front office is getting the message. Testimony can happen very often early in the case. It may be months, sometimes even years before the front office gets a well submission or gets other submissions addressing some of those issues. How do you get to see either the key testimony or some of the things that the experts might want to make sure you understand?
Yeah, and I'll start by slamming the brakes on the conversation by giving my disclaimer. My comments are in my official capacity as Acting Deputy Director of Enforcement. They do not necessarily reflect the opinions or views of the commissioners, the commission, or staff. So to answer the question, it's fairly unusual for the front office to get testimony transcripts. The way it will come up, and what Sanjay was referring to is, and there is an element of staff discretion that's involved, that there are points in time in an investigation, usually where you're close to recommending a settlement, and you've got questions about whether or not you can compromise on certain terms, or it's a litigated matter and there's certain litigation risk. And at that point, it'll be raised up almost always to the front office. Usually, it'll initially be in an email, and it'll also be after it's been through a fair amount of process. So if it's an accounting case, it'll be run through the Enforcement Office of Chief Accountant. If it's an issue involving an asset manager, it'll go through IM. If it's a litigated matter, or even if it's not, a potentially litigated matter, it'll go through the Chief Litigation Counsel. In my role as Chief Counsel, I might review something before it goes to the front office. And so it's pretty fully baked and heavily reviewed, but it does then go to now me and Sanjay, and before it was Gregory and Sanjay. It's, again, there's staff discretion. They should be identifying the key issues. It's on us too to see, we've been doing this for a long time. We know seeing a recommendation hopefully where there are issues, we can go back and ask questions. It might be that it's all handled through email. There might be a meeting with staff where we can sort of talk through the issues and tease out where the issues are. And it may get to the point where we do, again, it's not often, but I have in cases looked at transcripts.
So thinking about how we can best get the information in front of you, George, we discussed as we were preparing different ways to make sure Sam sees what you want him to see, whether it's an early white paper or a late Wells. What strategies do you find most effective?
I think it goes back to the beginning, right? Before you even get to the front office is, speaking to the staff, highlighting your key points to the staff. I like to have the opportunity, if the investigation has legs to it, it's going somewhere, to make presentations during the way, to provide your narrative, your view of the facts, and also to get into a dialogue with the staff and get their views on how important they think a particular testimony is and your view of that testimony. Ultimately, I trust the process that it's going to make its way to SAM, whether it's in a white paper or ultimately in a Wells submission. And then if you're able to get that Wells meeting with the front office, great, and then highlight, what I think what you want to do is focus on your most effective arguments, your strongest arguments to the staff. Now, you may not get that meeting, as Sanjay was talking about earlier today. They're not taking every meeting. Where they draw that line, I'm not exactly sure, and that's a little bit frustrating on the defense side. But at the end of the day, I think you've got to trust the process, and you make that well submission or that white paper that you're highlighting your key points. And as we talked about, is you have a 40-page well submission, have an effective, I think you said it, an executive summary, right, Greg, where your key points are up there so that they can see that right in the beginning.
So when you talk about a presentation, I want to understand how you think about how that interacts with what you were talking about, Sandra, with the testimony. Do you think it's effective sometimes to get out in front of the testimony and do an attorney proffer? I mean, for anybody. What are you thinking of in terms of getting the story in front of the staff where you might be able to be more helpful than a long testimony that doesn't quite help you or the staff?
Sure. In my experience, look, I've had an experience where, an investigation chugging along and then something else comes up, another issue. I clearly want to get ahead of it. It's going to get before the staff. I want to make that proffer and say, here, this is what happened, or our understanding of what happened. Obviously, they're going to want to speak to somebody about it. But I think ultimately getting ahead of everything and having your narrative is really important. But I take that with a grain of salt, and I think the staff does, is ultimately is, look, they want to hear from the underlying individuals themselves, not just from counsel, obviously, but I think getting ahead of any key issue and something that they're going to be interested in is really important.
Michael, could I add one thing? One thing
Please.
on the presentations, I've had matters where we're on like presentation 8 or 9, and when we say presentations, they're more educational, and and I've had matters, and I'm sure others on the stage have, that have gone on for a couple of years before they take any testimony, and it's just getting through the evidence and really using that as an opportunity to educate. Other times it's one targeted, where everything builds to one targeted presentation, and that's a different, maybe a lot more advocacy. But I think those matters where it looks like the staff is not going to roll up the sleeves and do that kind of digging, and they are really asking for that, can be very helpful. It's obviously more expensive, more time-consuming, but I've seen it be very helpful where, you're able to lead the staff along to your view of the case through those presentations.
And how do you balance out the written versus not written? Because on the one hand, you give them the written presentation, it's more likely to get in front of the senior people. On the other hand, they now have something that may be an admission or something in litigation. How do you all think about that?
If I had my druthers, I would never give a written presentation in advance of the face-to-face presentation. And the written presentation would in some ways be tailored to the reaction. There may be questions, there may be nuance that is more important, that comes out in the meeting. And invariably, once you have a meeting, the staff will say, can you confirm that in writing, or can you leave something behind? Can you give a PowerPoint? And that's a really weighty thing, because it has to be exactly right in writing, but it also has to be exactly right in your presentation. Because if you're making an attorney proffer, you better hold yourself to the same standard you hold your clients to when they're testifying. Because, and I'm not trying to be hysterical and saying you could be criminally prosecuted for it, though you could, right? If you lie to the staff, it could be a violation of federal law. That's not the real concern. The real concern is you lose credibility and your client gets harmed by it. So you've got to really, really vet that. If you're going to make an attorney proffer, you're going to try to get that story out of there. You better be sure that it is not just a self-serving narrative that your client has given you, that you've really kicked the tires.
Yeah, I mean, and every subsequent client of yours suffers from your lack of credibility in that matter. And then, I may not get a meeting with Sam and Sanjay on every issue, but I think I've, over decades, have enough credibility with Sam that I feel confident he's going to read my submission even if we don't have a meeting. I'm not going to blow that because I liked my case too much, right? You really have to kick the tires and probe. None of us do our clients any good if we're sycophants to them.
No, I mean, attorney credibility is everything. If you lose credibility with the staff, you have harmed your clients. You've harmed this client, you've harmed next clients. There is nothing that affects your credibility that doesn't harm your clients. And that's a tough conversation with some clients who just want you to hate the staff, want you to just be obstreperous, want you to be difficult, want you to go in there and say something that will not hold up under cross-examination. And there are lawyers who will do that. And sometimes that's the result of those conversations. But I can't emphasize enough to clients and anybody else that if I lose credibility with the staff, it harms the client directly.
So Sam, from your side of the table, and now you're probably reading more of these memos and presentations than I can imagine, what do you find most effective? And maybe the close other side of that, which is, what do you find least effective? What do some lawyers think may help their client, but they should probably know isn't helping their client in these submissions?
Good question.
Yeah, so I'll answer both, effective and not effective. And I'll start with a caveat. I mean, there's no one way to do this, and you could have different goals in going into the Wells process, and depending on those goals, what I'm about to say may or may not be helpful. For me, as the audience, if I am the audience, it's not rocket science, it's pretty basic stuff. Identify your key arguments and make those arguments. And probably what's not effective is making all the other arguments. You may have 10. You don't need to make all 10, even in the Wells submission or definitely not in the meeting. I think two things typically happen there. One is, we do read these, but if you're reading a 40-page Wells submission, and the first 10 pages are strong arguments, but then the last 30 are weaker arguments, it's really hard to come away from it without a feeling of meh. And you sort of forget the strong arguments. They get lost in all of the weaker ones. And then the other thing that happens, which is, to Greg's point, I think a bigger issue, I think as you get to your weaker arguments, you have to stretch. And you may end up in a place where you're stretching so far that you lose credibility. And I think that is, I agree, that is like the last, I think, for me as a consumer, that's the last thing that I want to see. And that sort of leads to the second thing that I think is effective versus non-effective. And that is, particularly in the Wells meeting, if you can be the truth teller, the honest broker, whatever the metaphor is, I think that's tremendously effective. And obviously, if you stretch your arguments too far, then and you lose credibility, that works against that. One thing I've seen a couple of times that I found very effective for me, and I think others on my side, is counsel who will concede issues. They'll say, look, on this one issue, you guys probably have the better argument, or it's a toss-up. But we still win because of these other arguments, and that I find almost disarming, and it colors, it gives an air of credibility to everything else that the person is saying. Obviously, you can't just do it to do it. It has to work. But if it can work, I think it's very effective.
What do you think, and this is really for everybody, about bringing a client to a Wells meeting or a presentation, whether it's the general counsel or whether it's the defendant or otherwise? Can that sometimes be effective or send a message?
We have very different opinions on this panel about that, I think. Just quickly, my view is, Typically, no, and I am not in favor of it unless we are talking about how much, like we bring in the audit committee chair or the CCO or somebody to talk about how much remediation there is, how seriously we take it. But a guy who can be a witness or just wants to argue and pound the table, I'm not bringing him to the meeting.
Yeah, my view on it is, look, if you're bringing the general counsel or someone like the audit committee chair and you're trying to send a message to the staff that they're taking this very seriously, that's great. But I also think there's the opposite side is it's helpful to us as counsel to have someone from the company there, whether it's the general counsel or someone, at a high level, to see what we're dealing with on the other side. Because sometimes they don't get that, yes, the commission is wedded to this position and they're not, they hear the arguments that we're making and they're not backing off.
So I'm generally not a fan of bringing clients to meetings with the staff for reasons, in part, what Sam said, which is very important to be credible there. So the staff may lay out 6 arguments, and you may say, well, if we litigate, we're more likely than not to lose on arguments 2 and 3, but we're very strong here, and if you look at arguments 2 and 3 as where you're likely to win, that's a very different resolution. So you can have an intelligent discussion that way. You can't have that discussion with the client in the room. With most clients, because most clients will be wedded to every argument that says there's no liability. So that's very difficult to have that completely candid discussion with the client in the room. However, and I thought about this after we did a little prep session out there, we recently had an experience that was exactly the opposite. It was a case that was highly, highly technical, and frankly, so technical that I couldn't explain what the client's trading strategy was. I won't even tell you because nobody in this room would understand it. The client understood it very well, and the staff understood it, and the client was utterly credible, and we vetted him, and we vetted it thoroughly, and we said, we need to have this meeting. It was a very productive meeting, and frankly, if it had been testimony, it would have taken 4 days, and it would have been a bloodletting. And it served its purpose because the client was credible, presented well. It was an utterly technical, truly rocket science type trading strategy. And the client was able to explain it. So there are times, but generally I'm very skeptical of them.
How about you, Sam? Does it sometimes send a positive message, or is it kind of a smile that you get to beat up on somebody and they're instructed not to answer your questions?
Yeah, so it has happened. I think my sense is that it's effective when it's a very sophisticated client, typically in-house counsel. That can be effective. The other thing that I'm sure has been effective, and it was not stated as we're bringing our client so that they can hear from enforcement, but it was pretty clear. There are a couple of cases where it's pretty clear that that's what the goal was, and I imagine that's effective too.
So we've talked about the end of the road where it's kind of that fork in the road where it's either we convince you or we can't, and we talked about the very beginning where there's testimony. Through that whole process, a lot of times we either know or sometimes we don't know whether there's criminal interest. We sometimes have been told by criminal authorities, we're watching you, and sometimes nobody's said anything, but we know it's the kind of case that somebody might be watching or would be interested. How do you approach those conversations to everybody, with your clients and just generally, even in preparing for testimony? Let's start with when you're not sure.
Okay. Yeah, so, Lauren Reisner was here before and talked about sort of the parallel proceedings in a major crisis where, there's different investigations. This is a step before that. This is not a major, you're not quite sure what it is. Say you've got an individual client. The discussion that I try to have with clients is to, one, as Sandra said, try to really understand everything about it. Try to use my best judgment to see, do I think it could be a criminal case? Does it feel like a criminal case? And to always have a discussion with them about the very profound act of testifying before the United States government, which is when you open your mouth to the government, you have a choice to make. do you testify or do you assert a constitutional privilege? And I never demean a constitutional privilege. It's there for a reason. But once you testify, it can't be different because the stakes are higher, because you say it's just a civil proceeding, it's just a deposition, it's just whatever, right? You've got it, you got one chance to get it right, and you've got to get it right. So that's, I think, what I try to do, and you can be very wrong. And we've all probably, in private practice, I'm sure Sam had this when he was a defense lawyer, those horrible situations where you're halfway through an SEC proceeding, and you hear from a special agent, the FBI. And you're not sure why. You don't even know why. Oftentimes they just say, well, because we're interested. And then you have a real dilemma on your hands because you've already committed to cooperating, right? Because when you're testifying, you're cooperating, whether you call it a cooperation agreement or not. You're cooperating with the government at that point. So you can't really put it back in the bottle at that point. So it's a real problem, and I think that's why I approach every case as if it could be a criminal case. And I'll shut up in a minute, but one thing that I think is very important, you have to apply your judgment. Is it likely to be a criminal case or not? Because if you take the instincts that, no offense to any former prosecutors who are here in the office, but many former prosecutors, when they first go to private practice, just say, well, just don't cooperate. Don't say a word. Well, okay, that's great, except if it is only a civil case, then you've just lost your adverse inference, right? Then you've dug the hole a little bit deeper if it's a case where your client should have testified. So I think it's a very weighty concern, and there was a time where I could confidently say this is absolutely not a criminal case. But those days are long gone.
Let me just add to that, for a long time on the SEC side, I have believed more often than not there is a whistleblower, right? There's somebody who's incentivized and you act accordingly. But whistleblowers on the criminal side are a relatively new thing. And I now, in the last less than a year, however long it's been since we have pilot programs and bounties available for whistleblowing to the criminal authorities, I think it is more and more likely that we find ourselves in parallel proceedings than not. I mean, maybe it was 1 of 10 cases for most of us in this room before that were parallel matters, or I don't know what the number is, but now it's a lot more than it was 5 years ago, 2 years ago.
And does that affect your advice as to whether to cooperate? You know, we would cooperate if we knew this wasn't criminal, but we are more reluctant?
It might. I mean, it certainly, I'm thinking about it more and running the traps more now than I was 2 years ago, for sure.
I think it does if you get to the point where the client says, I can take a civil, I'll happily pay money back. Say it's an insider trading case. I'll say, okay, I made $300,000. I'll pay a 2-time penalty. I'll pay $900,000 and take an injunction. But if you don't know if it's right, so in that case, if you could verify it, it will not become a criminal case. Then maybe that would affect your willingness to cooperate.
Yeah.
One thing I might add, it's on this topic, but it's when DOJ has surfaced, and so you have the SC and DOJ, and the cases that people like myself get involved in tend to, again, be more technical, maybe in the accounting or auditing realm. And one of the things that always I've noticed in a couple recent matters where we've presented to both at the same time is the issues underneath are the same, but they have very different perspectives in terms of the questions that they ask. For example, the SEC tends to be a little bit more technical, and DOJ might understand the technical underpinnings a little less, but is also asking about the same conduct. So I think it's tricky and it's hard, but it's really important to try to anticipate very different kinds of questions coming from both sides. You need to be able to answer the highly technical questions that may be coming from the SEC staff. But at the same time, I don't want to say this in a bad way, but dumb it down a little bit if you're getting questions that are not rooted in a technical understanding of the subject matter, but be able to answer, the criminal questions in a way that are also convincing. It's tricky and hard.
And so that's probably a good segue into settlement considerations, because the criminal authorities have some different settlement considerations from the SEC, to say the least. And there's some thresholds too, where I imagine, Michael, you can help the DOJ understand why damages might not reach a certain threshold as restitution, even though they might look that way as disgorgement. Do you sometimes kind of help walk the different authorities through potential damages, potential settlements, and why they should understand it in a certain way?
Yeah, I mean, there are experts that do a lot of that. I've done some of that and tend to do that more in FCPA cases where you're talking about, discord, or, the profit angle and the like. In my experience, they typically have their own experts there as well. And those can be very heated discussions, and you're talking about the same set of numbers, and you're in two different realms. And so, like anything else, if you're going to bring an expert in to do that, a lot of preparation, highly coordinate with your own counsel and client to really understand the position. And they can be persuaded, I have found in those situations, but you really have to do a lot of preparation.
So for the rest of you, how do you think of those when they're in parallel, both in sniffing out, you want to settle, you're thinking about a certain number, but you need to know that's the last number? And the same question to you, Sam, of are there magic words we need to know to ask you, is this it? Who's hiding behind the door?
I don't think there's any magic words. Obviously we work with the criminal authorities all the time. Those are some of our biggest, most important cases. But it's also, from our perspective, really, really important that we have a parallel investigation and not a joint investigation. And so there's only so much coordination that and it probably explains what Mike was just describing. Again, we work closely, but every investigative step we take, it has to be something that we think is appropriate for our own purposes.
How about everybody else? Is there a way you approach these cases? I mean, is it don't settle until you know this is the final line, or do you sometimes have to just jump in?
I think it's dependent on the facts and circumstances and how each investigation is moving along. Frankly, we've all touched upon crypto cases, and they have different, focuses of areas, right? So I think, it's dependent on what exactly the focus and how quickly they're moving. But I think obviously it's something that you have to be mindful of. And ultimately, if you can get a joint settlement or a settlement that closes things up all at once, that's great. But I think that's harder to get, it seems like, nowadays. That's been my experience.
I mean, for companies, it depends who your client is, right? I mean, for individuals, the SEC, in a parallel matter, the SEC is often typically the tail wagging the dog, right? Like, you are concerned about jail time. For a company, I think you're much more able to and ought to try to get a global resolution wherever possible, and at least it's in the art of the possible for companies, but for individuals, like, why bother? Your jail time is your consideration.
Well, I would say on the ultimate resolution of a case, it is always important at the very beginning of a client relationship, whether it's an institutional client or an individual client, to have a very, very deep discussion on what that client would consider an acceptable exit. Because every client's different. There are clients that will say, give you a single example. I'm 64. A 64-year-old client may say, surrender my license to practice accounting. Well, I guess I would consider that. A 40-year-old client may have a very different view about surrendering a license, surrendering an ability to practice.
Right.
So you can't wait until the end to do that. And with respect to institutions, we've talked about parallel proceedings, criminal SEC. There is a whole world of hurt out there for institutions, particularly if they have any regulatory scheme. And so I think you have to really think, what are the implications? It has happened to me. I won't say when, but I know it's happened to other veteran practitioners where you think, I did a great job for you. I got a great resolution. here's what it is, and I find out later, like, oh my God, there's this whole world of collateral consequences that I didn't think about that harm the client. And the client is assuming that I will have thought about those.
You mean beyond the like Wixie stuff?
Yeah,
You mean
beyond
like
the
some
obvious stuff.
state
I mean,
regulatory
there's a whole world of
insurance
things,
thing
right?
that you
Relations
don't know
you may
anything
have
about?
with your
Yeah.
limited partners, relationships with your landlord, relationships with your banks, relationships with the state regulators. Just, I can't even, you know, and so I guess it's really important to just have that discussion. What's a victory to you? I mean, victory is the wrong word. What is the least bad resolution that you would consider?
But I find that it changes along the process, right? I mean, at the end of the day, if the client's facing, you know, a fraud charge on a D&O bar or some sort of bar, but then you get it down to a non-scienter-based charge that doesn't involve the bar, then the client may have more interest to settle to that.
Sure.
As opposed to the beginning of the investigation where I'm not going to settle to anything because of the harm, the reputational harm.
Yeah. Yeah, that's true. I mean, that's a very difficult discussion because you run the risk at the front end of the relationship with the client saying, you mean, George, you don't believe me?
Right.
Maybe I need a different lawyer. Maybe Sandra will believe me.
Unlikely.
So, coming full circle then to maybe what we started with, what everybody started with this morning. Looking forward, we can't predict who the chair is going to be. We can't predict a lot of things, but we can probably predict that resources may not be added in the near future. Does that, and we've heard this morning some talk about potential limits on how long investigations will be allowed to run, a soft cap, a hard cap.
Yeah.
We've heard a lot of people talk today about all the different changes that we've seen in the last few months and years about what the SEC can even bring and where. There's no longer that fallback position, for example, to a causing violation, which was kind of the, somebody once called it a coward's pivot for when they didn't have it enough for even negligence. That's gone now. Have any of these changes, either from recent times or that may lie ahead, impacted your thinking on what you want to do with the cases you have right now? Do you want to wait and see a little bit? Are there different tactics you might take?
The biggest change for me is a very recent one, which is these conduct-based injunctions now, right? Like we may or may not have 102Es left in an administrative proceeding. We're not going to put Sam on the spot, although I would really like to put Sam on the spot about that. But for now, we're seeing conduct-based injunctions, and I think that is a game changer because if we have an accountant in-house or an auditor who is facing a negligence, what we all would consider negligence-based kind of charge, and they're going to bring that non-102E in federal court, that's a game changer.
They'll charge it up so it's a fraud case, but they'll bring it in federal court, which means
Maybe they will.
your resource issues, your jury trial issues, all those things. And in an era, if
Your indemnification
the one thing that we know, well, at least we can probably all be assured of, is that it's unlikely the SEC is going to get more resources going forward. So, everything else is kind of, and I know that if it was put officially to officials of the SEC, I'm not going to put Sam on the spot, they would say, no, we follow our cases through the way we do. If, we've wellsed your client, and if we have to sue, we're going to do everything the usual way.
So Sam, I will put you on the spot, but not on a particular case. Have you seen, without mentioning any names obviously, the recent cases change some of the tone of people coming in with arguments, pounding the table more on, I'll preempt this in the Fifth Circuit, or you can't bring this? Has the tone changed at all?
So it's not tone, but there are arguments that we're seeing that you can imagine much more often. And it's not any specific type of case. But yeah, I mean, it is something we're seeing. Again, I don't know if I've seen anyone pound the table, but definitely we're seeing that. And we're seeing, I don't think it's any secret that the Fifth Circuit is viewed as a very favorable place for folks on the other side of us.
Well, I made one promise at the beginning, and that was to land the plane on time. So I think wheels are down. Let me just thank all of the panel for joining us today.